Hello, and thank you for watching one of a series of our videos on disciplinary processes. My name is Warren Wint, one of the lead trainers for Total Success Training. I've held managerial and directorial positions in large organisations, and I've carried through a number of disciplinary processes. I've even gone through this in terms of the process we're going through today, which is on dismissal. It's an inevitable part of when you are a manager or a director, but at some stage within your career you will have to go through this. Now this can be quite a stressful situation, no matter how long you've been doing it, because at this stage you've now realised you've gone through the informal processes. You've gone through the formal disciplinary, you may be on first disciplinary, first warning, final warning, and now you've got to the point where you feel there is no choice but to go through this dismissal. Nothing has changed in relation to the situation that you're in. This could even be a situation where you are now at the final part and you've gone into this. But can I just say one thing? You've got to make that judgment as to what you need to be able to consider when you are looking to dismiss an employee. And we're going to focus on two key areas here. Are you dismissing on the area of conduct, or are you dismissing on the area of capability? Now, employment law gives you only 5 major reasons why it is fair for you to dismiss a worker. Number one, the worker's conduct has been unsatisfactory and has not improved. The worker's capability in relation to their ability to carry through the job in required standards. That's number 2. Number 3, the job is now redundant, doesn't exist because of changing circumstances. Number 4, the dismissal is in line with a statutory irregularity, i.e. let's say you employ a person has lost their driving licence for HGV. You cannot give them any other duties, so in relation to this particular situation, it would now be illegal for them to be able to drive, so they're unable to be able to carry through the job due to a statutory requirement. Well, number 5 is any other serious irregularity in relation to a substantial reason. So there are only the 5 areas there. And it's clear in the area, you've got to be clear in terms of the area of capability and conduct. They are treated as separate offences justifying dismissal. In fact, the ACAS code, the Advisory Conciliation and Arbitration Service, makes it very clear nobody should be dismissed for their first offence unless it actually constitutes gross misconduct. It's therefore very important for supervisors and line managers to recognise the difference between a warning for somebody's capability and a warning for somebody's conduct. And case laws indicate that employees who fail to recognise the distinction between the capability and conduct are much more likely to incur an unfair dismissal. Let's consider a situation where you're employing an employee, Jason, who's worked for the company for a number of years, very pleasant person, but has been unable to adapt to the new technology which has been introduced in relation to the core processes of his job. Despite plenty of training and support, number of meetings, training courses, one-to-ones, coaching, serious mistakes continue to occur. And over a reasonable period of time, this has been culminating in Jason receiving a final written warning. Now this is clearly a warning for capability in terms of Jason's case. But whilst he's actually being covered by the final warning, he actually commits a relatively minor health and safety breach against company rules, and this would indicate a disciplinary process. Now, the company's disciplinary process makes it clear that this breach warrants a formal warning. And the problem is that Jason is already on a final warning. Now, some organisations would decide to dismiss George. Now, this is deemed to be unfair. This would be a dismissal for Jason's first offence under the heading of conduct, which is a breach of health and safety, clearly is. His previous warnings have been for capability. So Jason should only receive a first stage warning for conduct. The final warning for capability still remains in force, but Jason can only be dismissed at this stage if the next offence that he carries through whilst under this final warning is one for capability. Now, some organisations do have separate disciplinary procedures for dealing with capability and conduct, and organisations can opt for this if they wish, but it's not essential. What is essential is that supervisors, line managers and directors fully appreciate whether the offence that they are dealing with is one for conduct or capability. And the law governing dismissal draws important distinctions between an employee's ability to do their job and their conduct whilst performing their job. And for that reason, it's important that any disciplinary proceedings and all preceding disciplinary measures show that clear distinction between areas of performance and conduct. This means that an employee who's already served the first warning for breach of capability, as we said, and has subsequently commits a conduct offence, should be issued with a separate first warning for the conduct, as we said in this scenario I gave. So, to simplify matters, A, conduct. This is where an individual will not work, cannot work to the standards required. So that's conduct. A person has, for whatever reason, will not work to the standards. Capability is where work cannot achieve the standards required. This is not down to their particular will. It is down to the fact that for certain reasons they cannot achieve it. With conduct, there are many factors which you can think of in relation to conduct, and these in a lot of organisations we work for are set out in terms of company handbook and company procedures. They could be for lateness, could be for insubordination, not doing what they should be, breach of health and safety regulations, it could be for theft, could be for fraud, could be for fighting, or other breaches of company rules which are set out, as I said, in the handbook. Now, what deems capability? Well, warnings for capability would be when the worker does not have a necessary skill, aptitude, health, or other physical or mental qualities to do the job to required standard. Now, disciplinary for a capability could therefore be deemed fair when the reason is for poor health, or lack of qualifications, where standards have been raised, or new technology introduced and the individual is no longer capable to deliver to the performance required. At this stage, you should look at the actual termination. Obviously, it's a final step dismissal and should only be taken if, despite warnings and going through the full procedure, conduct or performance has not improved over the required time period. Unless the case involves gross misconduct, the individual should have been issued with a final warning prior to dismissal taking place. I hope this clarifies this matter for you, and I hope that if you're going through this process, and if you're watching this video, you're probably watching it because there's an area that you're thinking about in terms of, am I doing the right thing at the right time? I always say when we do our training courses and seminars, have you done everything? Have you gone through the procedures? Have you sought advice from HR? Have you even gone to ACAS? Because they can give you plenty of advice on this over the phone and via email as well. Have you sought enough information and followed the procedures? Do you understand the procedures? Have procedures been adjusted? Have they been communicated to all staff? Have you been trained on these? These are some of the key areas you have to think about. You're watching this video because there's a question that you need answering. And when you get to this particular point, you need to make sure that you've ticked all of those boxes. In most cases, that if you've gone through the correct procedures, understood them, then at this stage, although it is traumatic, you would be following fair dismissal and rather than unfair dismissal. There are lots of other factors you have to take into account in relation to this. But this video only really concerns this idea of the concept of whether you are dismissing somebody for conduct or capability. Thank you for watching this. I hope this is clarified. I hope it's given you some information. I hope you are able to conduct whatever you need to with the right procedural processes. And I always say one of the things about disciplinary is it should always be conducted in a way in which it leads towards, or possibly towards, a positive outcome rather than a negative outcome. And this is just one step in relation to managing this particular process further forward. This is a difficult situation when it comes to dismissal. It's a stressful situation. But I hope that if you have to go through this, you do it in the best possible way so you can walk away from the situation knowing that you did everything you possibly could within your power to ensure that the employee was dealt with in the most fair and honest way in which you could do that. Thank you for your time. Again, we run workshops and seminars. Please contact us if you need further information. Our website is www.totalsuccess.co.uk. My name is Warren Wint. I'm one of the lead trainers here, and I wish you the very best in all of your proceedings in the future. Thank you very much.